the court to consider changing the current custody orders and issue no further contact between the children and the plaintiff. Plaintiff should be held accountable for his actions regardless of stature or representation. That's all.
Okay, thank you. I don't need anything else, Mr. Kelly. What the court will do in this matter is the court has read the pleadings, obviously is well aware of the file in this case. The court does believe that the plaintiff has met the Vavarka threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client?
Right.
Okay, Mr. Connley, if you step forward, we'll have you sworn in and then we'll take some testimony. When I say brief testimony, I don't need to get into.
Sure. We'll keep it.
Here is the setup, folks. Dad's been fighting tooth and nail for his parenting time, and right now, we're about to see just how much resistance he's facing. Watch closely. This is where the legal mechanics kick in. Notice the judge carefully sets the tone, brief testimony only. In a courtroom, brevity can make or break your case, and Dad's lawyer knows it.
Straight to the point here. Have you been getting your parenting time?
No,
Why not?
but she is refusing to let me see them.
Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. House, do you have any questions for the plaintiff? No?
Ms. Putnam, how do you know Mr. Connley?
He is my son.
You heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pick up and drop offs for
I
parenting
do.
time? Has there been occasions when you have gone with him to go get the girls and anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park and we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls. His first visit that he was supposed to was I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was going to refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted. That help in terms of actually getting parenting time to occur?
No, she just did the same thing to the police.
Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time that stated that the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
And you don't remember if she was not there or she refused?
I don't remember that specific time.
Okay.
I have it written down at home, but I don't remember.
Okay, Ms. Couch, do you have any questions
I
of
do,
this witness?
yes. At what age did Zach Conley start wearing diapers?
Judge, I'm gonna object to it.
Ma'am, that is not germane.
No, I am.
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, et cetera, okay?
Okay.
Go ahead.
And you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes. Or December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Okay. Even though the order was for the 29th, wasn't that? the order
Whatever,
that the judge put
whatever
in
day,
place?
whatever judgment day.
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment
And,
that you slammed the door in my face. I have it on video. Yes,
and you came alone, correct?
I did that day.
Okay.
Yes.
That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witness? No? Okay, check that order because there was some, Ms. Couch, you raised some issues concerning the, I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups
And why is that?
because he was our children, and I don't believe that he needs any more parenting time.
Okay. You understand that there's an order for parenting time.
And if it was your children, you would be sending them with him.
Yeah, I'm just asking you a question. You understand that it was parenting, that it was ordered,
Didn't you deny that? Didn't you go on base and deny it after the fact?
not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that.
You guys did receive the pictures that I submitted to the court as well, correct?
Anything that was filed has been in the file.
I would love you to take that into consideration. Please.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025, and it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay. Let me clarify that because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't, I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with a therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay. I'm not aware of any report from Summit Point. It may be in the file, it may not, but you've not introduced that today. And you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter. So Okay, Mr. Kelly, do you have any final argument in this matter?
As the court's already touched on a little bit, this is our fourth motion to try to get him parenting time. We simply want him to have his parenting time, with a threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from Ms. Couch. We request that the children be turned over to him today, that he have custody and parenting time with the children until the evidentiary hearing occurs. We'd request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's voiced she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time, 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank you.
Thank you. Ms. Couch, your closing argument.
I am acting I just want my kids to be safe. That's all.
Okay, thank you. Well, the court has heard the testimony in this case. The court will note that, again, that apparently there had been a denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has, in fact, denied parenting time. And court notes that as a result, she has withheld the children, that she's failed to comply with the order of...
But there's reason, sir.
Excuse me?
There's reason.
Okay.
Valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify. You had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025. That all four of those orders she's failed to comply with. The court has reviewed the file. There's been multiple show cause hearings. She has previously been held in contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time, and that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact she is ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice.
Boom! Courtroom drama at peak intensity. This is a textbook example of contempt of court. When repeated orders are ignored, judges don't just sigh, they act. 30 days behind bars, plus compliance with prior financial orders. And yes, the tension here isn't just legal, it's deeply personal. You can practically feel the stakes for both the parent and the children. And yes, YouTube viewers, that's why contempt exists, to enforce the rule of law when warnings fail.
But the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until such time as you've paid the previously ordered attorney fees of $1,000. So, ma'am, you can go with the sheriff, and
Are you serious?
this matter is concluded. You're free to go.
Who's
Have a good
sucking
day.
who's around here?
Oh,
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No, what's going
If you
on?
keep going, I can go as long as you want, ma'am.
I just want a relationship with my child. I want my parenting time. I want my parenting time that was missed. I would like it made up because this is just ridiculous. It hurts the child. It no longer. Well, yeah, I don't like it. I don't feel good, but I'm not going to jump off the 36th floor about it.
Okay. Court notes, and you had mentioned sometimes there was an order regarding custody, parenting time support, and contempt in which the court awarded through the referee at that time. There was a referee hearing in September and October of 2024. The order having been entered on October 22nd, 2024, which awarded you joint legal custody, physical custody, and physical custody. And it provided for parenting time in alternating weeks and alternating holidays. And there was another referee order, as I said, on January 23rd, 2025, which held her in contempt for denial for those particular months. And you're saying that since, because it's the last one under the January order would have been sometime in December. So you're saying in basically January and February as well, you've been denied parenting time?
Not only that, but I'm also saying I have been denied parenting time, period. I haven't received 1 minute of parenting time since we've been separated.
Well, let's focus with me.
Okay.
I'm asking you January and February
Yes.
this year.
Yes,
Okay. And I would assume anything in March.
nothing.
Okay. Thank you.
Well,
Ms. Adams, do you have any questions of Mr. Hillier?
I have so many questions, but that can't be addressed here today.
Okay.
I mean, but yes, I have a lot of questions.
Well, this is your time. If you have any questions concerning the denials, this is the time to ask them.
I mean, Your Honor,
Okay, I'm going to let you have a chance to testify in a moment. I'm just asking, do you have any questions?
no, Your Honor.
Okay. Now, ma'am, what I'll do is have you raise your right hand, be sworn in, and then we'll proceed with you.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes. I do.
What would you like to tell me, ma'am?
Your Honor, we was together, when I had my daughter, I decided to stay with this man. I knew about his past addictions, I knew about all that. I know that's neither here nor there, but it does play a role in what's going on. I left him when our daughter was 2. He got back on drugs, as he stated himself. So we separated. This time around, he got clean. I decided to help him. He went to check himself in the VA. I said, okay, I will watch your house where I used to once live. I will watch your house. I will check your mail. You know, I agreed to that because I had my daughter, my dad in my life. So I know the effect that has on a child and a girl at that. So I helped her dad so he could be back in her life. And he got off drugs until he came back home. I have no proof as to whether he was using or not. I just know his behavior changed. I went back to my apartment, which I had, but before I did that, I found some disturbing videos in my daughter's phone sent to her dad, which he just spoke about himself because he said I accused him. I sent him a message asking for some type of clarity because my daughter don't do things like that. I mean, they're disturbing. I don't know if I can address that here. I don't know. if I can even say what it's about, because I don't want to get in trouble, but they were disturbing. There was an investigation. Mr. Hilliard went and handed over his phone. I handed over mine. I handed over my daughter's as well. The investigation was closed. I have no clarity on that situation, but that's how I'm holding parenting time.
Stop. Who did the investigation?
The Battle Creek State Police. Emmett came first because where I live in my apartment, not as.
Okay, so Battle Creek City Police?
Yes, sir.
Okay. And you said, and then, you said Emmett did an investigation or no?
Well, no, Emmett came because technically I'm on the cusp of like downtown, and I'm on Keenan. So I know you're familiar with your veteran. So it's like Emmett came first, but then the Battle Creek Police and everybody came on Mother's Day.
Okay, okay. Doesn't matter when they came.
I know, I'm sorry.
When, so Emmett Township, because you were there, did they do an investigation?
No, the Battle Creek Police Department did.
Okay. And I think he said that CPS had investigated as well. Did CPS do an investigation?
Yes, sir.
Okay. And I think because we haven't heard anything that city police and CPS didn't find anything, did not substantiate, is that correct?
Yes, sir.
Okay. And I understand why you may have some issues when if these things come up. It's justifiable that you're concerned, but if you want to change a court order, you have to come into court to do it. You can't do it unilaterally on your own, okay? Because that order still stands until it's changed. What else would you like to tell me?
That's it,
Okay, then tell me, because clearly the referee had previously held you in contempt for denial of parenting time for, again, periods of time through September through December. And now there's the denial as it relates to January, February, March. Why have you not allowed that parenting time? What?
I mean, just the personal. Have you seen the videos, Your Honor?
Well, presumably.
I'm concerned with handing over my daughter to somebody. It's too late after something happens again.
Presumably, the police and CPS all saw the videos. Is that correct?
Yes.
Okay. And they weren't concerned enough to take action on it. And I'm not saying that they shouldn't, but usually they're very vigilant on these particular types of things. You understand? And so you do not dispute that you've kept the child from him, at least in January, February, and March.
Yeah.
So it looks like basically 5 weeks worth of parenting time. Is that accurate?
Yes.
Okay. Anything else that you'd like me to be aware of?
No.
Okay. Now, sir,
Other than Mr. Hilliard did just go to jail for dropping dirty on drugs. They say he's with Michael Horn.
okay.
He's on probation for a DUI. Yeah.
Okay. Well, we can address that. Go ahead, sir. What else would you like to?
Okay, just to address that, I drop voluntarily through the VA twice a week, every Monday, every Friday. I have all results right here. Well, at least in November, December, January, February, and March. Another thing,
Okay.
our phones, my daughter's phone was turned over. April's phone was not turned over. My daughter's phone indicated that the email, text message was sent to her phone and then to my phone back to back. That's why I called the police when I called her on Mother's Day to wish her a happy birthday. And I got the message right here on my phone where she tried to use it and jack me up with the court. It's written in text. We'll see what the court thinks about it. I immediately called the police.
Okay.
And so
Okay.
this is innuendo bullcrap.
Okay. Anything else germane to this particular hearing, sir?
This particular hand, I would just like my parenting time.
Okay. And ma'am, anything else that you have?
I'm just really concerned. I never got no clarity on the situation, if it was or it wasn't. It'd be too late if I did. And to see his still, now his behavior back into drugs, I'm blaming me for drugs.
Okay, one more thing, Your Honor.
Hold on.
You know,
Well, you understand that he does have drugs test as he said, every Monday and Friday through the VA. You aware of that?
I am.
Okay.
Is there,
And he has the test results there, as he states, from, I guess, November, December, January, showing that they are not, that they're negative. So I understand your concerns, but you have to have facts and evidence when you come to court. You just can't make wild accusations. Anything before the court makes a ruling.
I'm just trying to protect my daughter, Your Honor, and this man is on probation for a DUI. Granted, people change and he does still drive okay, but he just dropped dirty and went to jail a week ago, or a week ago. Then is also on probation for assault and battery, beating a girl in the head with a shovel. Why would I anybody done that? Okay.
And what happened is, to present all that, these are just accusations you're making. It's not evidence until you have proof of these particular things, which you have a right at any hearing to bring proof, bring witnesses, bring exhibits, etc., which you have not done, so the court can only accept what your testimonies are in this matter, okay?
Yes.
It does appear in this case that the court has referenced the orders that have occurred. There was an order of October 22nd, 2024, which provided with the parties joint legal and physical custody, that they were to have alternating weeks, alternating holidays, and that there had previously been a finding of contempt as well back on, or from the referee back on January 23rd, 2025, in this matter. So clearly, man, you have been in contempt in this case. And as a result, based upon the testimony before the court today, the court will find that you, in fact, are in contempt of court for denial of parenting time. And the referee had previously had not ordered any makeup parenting time in this matter, simply held you in contempt, and had, in fact, assessed some cost at that prior hearing leading to the January 23rd, 2025 order. What the court is going to do, ma'am, is at this point is you have to turn the child over to the defendant. And what the court is going to order at this time is, because I'm not going to go back beyond the prior order saying that he's entitled to his 5 weeks of makeup parenting time and his regular weeks. So it means
Here's the kicker. Dad now gets 10 straight weeks of parenting time. That's not just a number. It's a judicial hammer swinging to correct months of denied custody. Notice the strategic mix of enforcement and protection for the child. Judges aren't just arbiters of law. They're actively shaping family dynamics when compliance fails. And for anyone watching, this is why following court orders isn't optional.
Would have the child for 10 weeks straight because of that fact. What the court will do, ma'am, is at this point, the court is going to remand you to the custody of the Calhoun County Sheriff. And what will happen is you will remain in the sheriff's custody until the child is turned over to the defendant. Okay? So what will happen is you're going to have to get a hold of somebody to get the child to the defendant so that he gets his parenting time, which will be 10 weeks. And then after that 10 weeks, then we'll go back to the alternating weeks as the order states. So until that occurs, if in fact the child is not turned over, then you will remain in the custody of the sheriff until such time as the child is turned over. Okay? That will conclude the hearing. What, sir?
Yeah, and I spoke with the administrator and my child's teacher today, informing them of this hearing or this court appearance today, and I can go pick up my child from her school.
Certainly, you can. So what will happen is the plaintiff is going to have to go to the sheriff, the company of the sheriff at this point in the custody. And once you've been able to pick up the child, you can contact the sheriff's department and confirm, well, you're probably going to have to come down here because we don't want phone calls because anybody can say, this is who I am. And yes, I've got the kid. So you'll have to probably come down, confirm with the sheriff, give them ID, showing who you are, and confirming that the child is in your care. And at that time, the plaintiff then can be released from custody.
Understood.
Okay? Okay, thank you.
Well,
That will be the order of the court. You're free to go. Have a good day.
thank you.
And I hope everything works out after this point.
May I call somebody on?
Excuse me?
Can I get a hold of somebody?
Well, they'll let you call somebody from the jail at this point.
I have a car.